Good morning, Liberty. It is Wednesday morning, February 13th, 2019. My name is Michael Boldin, broadcasting live from here at the 10th Amendment Center, 9:30 a.m. Pacific time. We're in my home office and studio here in downtown Los Angeles. So good morning to you, good afternoon, good evening, wherever, whenever you happen to be watching, whether it's live right now through our YouTube channel or later on in the archive in any of our other platforms like BitChute or over on Facebook, Twitter. Of course, our podcast editions, iTunes, Spotify, Stitcher, and elsewhere. I appreciate you spending some time with me today. I want to talk about just an overview of the Supremacy Clause. We so often hear, at least in the work that I do at the 10th Amendment Center, that anytime basically anytime people happen to like a federal policy, they argue Supremacy Clause. The states can't do anything about it because the Supremacy Clause says otherwise. And vice versa. If they dislike a policy, they make the same type of an argument. It's based on their own political viewpoints, but they're not really backing it up with any constitutional history. So I wanted to kind of go over a general overview of the background of the Supremacy Clause and then also what it really is. There's three words, in pursuance thereof, that explains really what it meant. But before doing that, I want to say hi to my friends out in the live chat. I appreciate all of you who spend so much time with me here on a regular basis. Ward Lawrence, good to see you. I sent you an email last night, Ward. Not sure if you got it yet. Existence, hi from Kentucky. Bob Brewer made it on C-SPAN this morning. That's pretty cool. Tyler B., Denver Libertarian. Jazz Creed, it's a username I haven't seen yet if I have, I apologize, but welcome. And hi to EHP Training. Of course, make sure to smash the like, keep leaving some comments, share the link with friends and family, wherever you are, whatever platform you're on. That does help us spread the word. So let's get right to it and talk about the Supremacy Clause. This is probably one of the most misunderstood and abused provisions of the Constitution. Some of the other ones are general welfare, commerce, necessary and proper. And I think we'll probably, over time, we're going to do some shows on all these different things, nullification, anti-commandeering doctrine, and on and on and on, and just kind of mix that in with some of the other conversations that we've been having here. So we put together a resource page that you can find through our homepage over at 10thamendmentcenter.com. I do have it linked in the show notes, of course, and then, of course, all of our show notes and archives are over at 10thamendmentcenter.com/Good Morning Liberty. But here, let me pull this up here so those of you who are watching the video can see this. It's our Supremacy Clause resource page, and of course, it starts with the text of the Supremacy Clause. And I'll just read it to you quickly here. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. Now, some of that might be confusing to kind of entry-level readers of the Constitution, people who haven't read it or studied it or read the words of the founders explaining it. That may sound like a lot of legalese. It is a legal document, so of course it is legalese and it has a very specific meaning. Now, I'm thinking most of you spending time with me live, at least right now, have a pretty good overview of where I'm going with this. So if it's easy peasy stuff, let's at least see if we can come up with something interesting anyways. So this from our page, of course, and this is also in the intro in the show notes. This is, again, the Supremacy Clause is one of the most understood and abused provisions in the Constitution. Nearly every American will tell you the Supremacy Clause means the federal government is absolutely supreme in all it does. And every one of them is wrong. Now, we hear this all the time. Well, if they cover some work that we do at the 10th Amendment Center in a mainstream media outlet, newspaper, online publication, TV, Rachel Maddow, Southern Poverty Law Center, all the places where we get hit pieces, LA Times, Reuters, all this stuff. Even if they're sympathetic to what we're working on, or they're sympathetic to our approach. So, for example, when we work on things like we've been spent a lot of time against mass surveillance, for example, we'll find a lot of people in the mainstream media, at least the individual reporters, sympathetic. But somewhere in the article, it almost always will have an expert quoted, some kind of constitutional law scholar who says, well, the Supremacy Clause says federal law is always supreme. Now, if you're looking at this, what I'm looking at here, I'm pointing my screen here, or listening to what I read, the Supremacy Clause says absolutely nowhere that all federal law is supreme, period. It just doesn't say that. It has this other legal jargon about laws made in pursuance thereof, treaties, blah, 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 blah. And that's how we put it in this intro page as well. The problem is when they say that, they leave out the three most important words in the clause, in pursuance thereof. And I'm going to go backtrack a little bit here to an article written by Brian McClanahan. If you're not listening to Brian McClanahan's podcast, you should. He's a pretty awesome guy. He's written a bunch of books and does a lot of great constitutional history research and writing. He wrote an article that we published here at 10th Amendment Center back in 2010. It was about a Health Freedom Act that was signed into law in Idaho. And without getting into the details of that, basically the national news media said, Supremacy Clause, you can't do this. This was the same argument that we always hear. You can't actually do anything that's different than the goals of the federal government because all federal acts are supreme and everybody must comply. And so Brian decided to lay the smackdown on this, and he really did. He goes through a lot of the history of this, primarily. The first part of the article I'm skipping through here. If you're watching, I'm scrolling through this because it's kind of setting the stage for that current event argument. And he then leads into the Supremacy Clause, which is in Article 6. And again, he puts the text of it and focuses on the part where it says, which shall be made in pursuance thereof. And then he writes, quote, the key, of course, is the italicized phrase, all laws made in pursuance of the Constitution or those clearly enumerated in the document were supreme, state laws notwithstanding. In other words, the federal government was supreme in all items clearly listed in the document, in the Constitution itself. So as long as the federal government is acting to pursue the Constitution, then what it does is supreme. So he then goes into the history, and I think this helps us understand it a little bit better. A lot of times when we study like the Philadelphia Convention or the Federalist and the Anti-Federalist Papers or state ratifying conventions, things like that, we want to hear what they were advocating for. But oftentimes understanding what was rejected in the Constitution, what was proposed and then they said no to, tells us even more. And I think the Supremacy Clause is a great example of that. And one of the things that was proposed early on, and it was introduced by Edmund Randolph, was something called the Virginia Plan. It created this was at the Philadelphia Convention. They were coming up with, how are we going to structure this new government? Madison had been writing some letters to George Washington about what he wanted to do before he even got there, and before Washington had gotten there. And they basically formulated this plan, and it was introduced in May and debated on the 31st of May, 1787. And McClanahan writes, in Edmund Randolph's initial proposal called the Virginia Plan, the national legislature, he put it in quotes because they wanted to have a national legislature, not a Congress representative to separate houses, that had the ability to, quote, legislate in all cases to which the separate states are incompetent, and to, quote, negative all laws passed by the several states contravening, in the opinion of the national legislature, the Articles of the Union. So the original proposal from Madison, Randolph, and others was to have a national legislature. Congress would be legislating on everything. And then Congress would then be able to look at any state or local law and make a decision. I'm not sure if it would have had been done by resolution or if it had to be done by some type of a vote or whatever. It may be a committee, something. But the proposal was that Congress would review any state or local law and then have a veto power over all of them. They would have review, like judicial review, but hand it to Congress over the states and local communities on any issue. Not some powers delegated to the feds and then the rest reserves to the states. like in the Articles of Confederation or in the Constitution under the 10th Amendment, but instead a national power over everything and a veto power over everything. So in other words, the states were going to be mere subdivisions, political subdivisions of the federal government under this proposal. So there was some debate, and Brian McClanahan talks about some of the debate and opposition. So like Charles Pinckney of South Carolina, they were challenging the word incompetent. So if the national legislature could legislate in all areas which are in the states are incompetent, well, that's a term of art. I mean, really, who makes the determination? Well, now we determine that they're incompetent to do this, and it could change from year to year, and it creates a very centralized structure. Now, Edmund Randolph himself, he actually did. His view was no, we weren't trying to create a situation that would destroy the states, and I think he was telling the truth, and maybe he didn't understand completely what he was trying to do here. But James Madison, on the other hand, I know specifically, he had written to George Washington before the convention, and he said specifically so he considered a national negative, a national veto from Congress, the executive, whatever it may be, a national veto over the states as essential. And he thought it was a defensive project to have a national veto. And he said without that, the states could, and it was in his terms, evade and defeat any act of the federal government by simply opting out of them. And so he thought that they had to have a national veto. And McClanahan gets into this as well. He says, James Madison, the author of the Virginia Plan, was not as forthcoming as to his sentiment as Randolph. Ultimately, Madison preferred a negative over state law and wished the national legislature to be supreme in all cases. But he was not in the majority. So they actually then again brought this up, this national negative, of a few days later, about a week, on June 8th. Charles Pinckney, who presented a draft of a constitution shortly after Randolph offered the Virginia Plan, believed a national negative necessary to the security of the Union, and Madison, using imagery from the solar system and equating the sun to the national government, argued that without a national negative, the states, quote, will continually fly out of their proper orbits and destroy the order and harmony of the political system. And McClanahan says such symbolism made for a beautiful picture, but it belied reality. So this didn't win. They voted it down. It was 7 states against and 3 for, with Delaware divided. And the point I'm making here with this kind of interesting history story, maybe it's boring, I don't know. I think it's extremely interesting. But what's important about it is that they actually proposed the idea that the federal government would be supreme in everything. This was a very specific proposal, and they rejected it. They said, no, thanks. We're not going to do this. Even though some very prominent people wanted it, some very prominent people thought it was urgent and completely necessary and defensive against the unruly states. They said no. So, no, the idea that the federal government is supreme in all cases is a lie, a total lie. So the next piece that I want to cover here that uncovers a little bit more, well, I'm not going to get into too many details, but that's going to get into a little bit more detail on it, though. Shine a little bit more light, I guess, is a better phrase for it. Is this article that we published from a volunteer that wrote for us quite a while ago. I haven't seen him in a while. Ronald Martin did some really good writing and research back in 2013. He basically wrote a little bit about Luther Martin, and I think he can be called the father of the Supremacy Clause. I mean, some people would probably debate that, and here's why. So after the Virginia plan, this whole national negative was rejected. There was a competing plan. I think it came from Patterson in New Jersey, the New Jersey plan. And this was basically a complete competing plan to, in essence, just kind of amend the Articles of Confederation and make adjustments to it. So you had the one plan, Virginia, that was for a total national government, total national supremacy. And on the other hand, you had the Jersey plan, which was totally federal and totally decentralized. And then you had this third idea from Luther Martin. And he was very well respected. He gave lots of long speeches. People listened to him. Maybe he was bloviating, I'm not sure. But, he was held in high regard. So he proposed, and this is from a letter that was, covered in this article by Ronald Martin. And he proposed, he says, in substitution to these ideas, I propose the following clause, which you will find very material different from the clause adopted by the Constitution. I actually think it's pretty similar, but maybe he would know better than I. He says, the legislative acts of the United States made by virtue and in pursuance of the Articles of the Union, and all treaties made and ratified under the authority of the United States shall be the supreme law of the respective states, so far as those acts or treaties shall relate to the said states or their citizens, and that the judiciaries of the several states shall be bound thereby in their decisions, anything in the respective laws of the individual states to the contrary notwithstanding. He was probably being nitpicky because they changed a national negative, which was competing with no federal supremacy, into this in pursuance of the Articles of the Union. And that, to me, makes sense. It's like, okay, if you're going to have a national government or a federal government, well, what it does in its limited sphere should count. But everything else, and mind you, there's only, if you look through the whole document, I know a lot of people say Article 1, Section 8 is the entirety of all federal powers delegated to the federal government, saying 17 or 18 is a number. I know Judge Napolitano often says that, but it's not really correct. If you read throughout the document, there's about 30 to 35 powers that have been delegated to the federal government. Now, these days, they legislate in everything. They tell us what size our toilet has to be, what kind of, like the size of a street sign in our local neighborhood, what kind of light bulb we can buy, what kind of plants we can grow in our backyard, what kind of dairy we can consume. They tell us when we have to go fight and die for them, how we can defend our homes and our families, or whether we can or we can't. I mean, they do legislate in every case. And so the original plan is how they've done it. Now, that's not how it's supposed to be. And then again, we have these competing visions. The national version was absolutely rejected, and instead accepted in its place was something that was in pursuance thereof. And those are the three key words, in pursuance thereof. As long as the federal government is carrying out the delegated powers of the Constitution, then its acts are supreme, and never in any other case. And I would say a vast majority of what they've passed in modern times, some people would say 60%, 90, 95%. Let's say you said everything they did was unconstitutional, everything. Well, once in a while you'd be wrong, and almost every other time you'd be correct. So I think you're safe in just automatically having a knee-jerk reaction referring to every federal act as unconstitutional, and therefore, once in a while, you can be incorrect and be okay with that. So I do want to go over to the live chat. I've got one other article that I want to cover from my good friend Chris Ann Hall. And existence says it clearly means exactly the opposite of what the drafter said it meant, right? Tyler B., I really hate government in our lives. Larry Clark, I'm late. I do appreciate you stopping by. I saw that you had posted in the archive from Monday's show on turning off the resources to the DOE and NSA, so I appreciate you, Larry. So back over to our articles here. The last one I want to cover, as I mentioned, is from Chris Ann Hall. And Chris Ann goes through a lot of the same basics that we're talking about here. She refers to Article 6, Clause 2, gives the text of the Supremacy Clause, and then she points out, and I think this is interesting, there are three things that the Supremacy Clause tells us. And I think this is kind of the key, what we learned. So what is the Supremacy Clause supposed to do then? And she breaks it down into these three things. One, the Constitution shall be the supreme law of the land. The Constitution is the supreme law of the land. They always tell us federal law is supreme, and that's what we always see in these mainstream articles. You see the great Dean Erwin Chemerinsky from UC Irvine often called upon to shoot down any opposition to federal acts that he happens to like, based on a political motivation, I think. And he'll say, well, federal law is supreme. It never says in the Supremacy Clause, if we go back to the text, it never says federal law is always supreme. The Constitution is supreme, and laws passed to carry out the Constitution are therefore supreme. So, in other words, the Constitution, the document, nothing else. Chris Ann says then, so 1, the Constitution shall be the supreme law of the land, the laws of the United States, which shall be made in pursuance to the Constitution as supreme law of the land. And 3, treaties made under the authority of the United States shall be the supreme law of the land. And treaties can't just like, they can't have a treaty to ban all guns, or they can't have a treaty to ban you from having marijuana, although they do. So it's a matter of people learning that they're not supposed to do this and rejecting it, I think. And Chris Ann actually points out in an article, which I think is really good. And again, all the things that I'm covering here, they're linked in the show notes here on YouTube. And then also, I do have it always posted in the archives over at 10thamendmentcenter.com/goodmorningliberty. And she points out, quote from Alexander Hamilton, Hamilton was a liar, a flip-flopper, and he often made the case, the more I study this, especially the ratification debates in New York, he would make the case for something to convince people to get on board, knowing full well that he wasn't on board with that and that he was just going to try to do something different later. So I guess Burr dealt with the guy. So, but the thing is, when they're making a case for something and people are agreeing to something made on what is presented to them, that is what holds the legal impact. So the legal meaning of the Constitution really relies on that as well. Not what he wanted to do with it later. Hamilton was awful. So if even Hamilton was saying the right thing, that tells you a lot. So in Federalist 78, she notes that Hamilton wrote, quote, there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. This is just backing up the whole idea that laws made in pursuance of the Constitution are supreme and everything else is illegal. It's void. And then, of course, it has to be treated that way, too. And she just repeats that one more time in her article. The Supremacy Clause codifies this very principle, that any law made by Congress that is not made in pursuance to the Constitution is no law at all. And unfortunately, too many people have treated them like their law just because Congress passes them and a president signs them. And I think more and more people are starting to kind of wake up that they're starting to wake up to the idea that they can reject federal power, even though the federal government says that they're not supposed to. And that's what we see in this whole nullification movement that we've been working with for so many years. Larry Clark says, I love Chris Ann as well as the 10th Amendment Center. I learned so much from both. Awesome. Thank you. Matthew Butts does not like Chris Ann's views against libertarians. I don't actually know about that at all, but that's interesting. She's always been great with me. So she does really, really good constitutional work, and sometimes we disagree, which is awesome too, because if we agreed all the time, there'd be something weird going on. But this article is excellent. Again, all these links, these 4 links that I'm talking about, I urge you to read them when you have a chance. They're in the show notes here on YouTube if you're watching live. Otherwise, or even in the archive, you'll see it in the description. You just have to click the More button. Otherwise, 10thamendmentcenter.com/goodmorningliberty, all spelled out, is where you go for all of our archives. And of course, how you can subscribe to all of our various channels as well, rather than just watching on YouTube. I know a lot of people ask us for other channels and podcasts, etc. So I hope you found this interesting, educational, fun to listen to, informative, all that stuff. I'm very grateful for all of you spending some time with me again here today. I really appreciate it. That you're willing to kind of listen to me ramble on about these things. I think it's awesome that we've been doing this now. I guess it's since July. So July, August, September, November, December. Almost 8 months. We're closing in on a year of this. So that's pretty awesome. Every Monday, Wednesday, Friday, 9:30 a.m. Pacific time, we're going to keep rocking. And then if things keep going well, maybe build it up from there. But of course, please smash that like button, share the link to this video or the audio with your friends and family, whatever platform you use. Of course, leave some comments as you go. I want to hear your thoughts, and feel free to send an email over to team@10thamendmentcenter.com. 10thamendmentcenter.com is all spelled out. I hope you have an awesome day. I appreciate everyone joining, everyone from Tyler, Existence, EHP, Denver Libertarian, Bob, Ward. Who else am I missing? Matthew, Larry. Cool. You guys are all awesome. Thank you so much for being here. Have a great Wednesday. We'll see you here next time at Good Morning Liberty. Have a great day.